Welcome to How to Impeach a President, a seminar on the constitutional remedy of last resort in the age of Trump. My name is Professor Michael Hiller. I'll be leading your seminar today. But before we get started, I just want to tell you something that happened a couple of days ago. I was speaking to a group of seniors about Medicare, and we were talking about the significance of Medicare as a program, and I was thinking to myself, I wonder what it must have been like in the 1960s when such a transformative program was being enacted, what it meant to the people at the time. And the response I got was both immediate and universal. It was, they didn't think very much of it. They didn't think of it as a transformative event. And it occurred to me at that moment that history sort of passes us like a speeding train. And contemporaries in the moment really can't appreciate the significance of the events as they're unfolding. And so every once in a while, we need to stop and really consider what's going on. Because right now, today, we are going through what is most likely the most consequential investigation in the last 100 years, and that is the impeachment inquiry of Donald Trump. So today's seminar is all about just that, the significance of what's going on and how best to understand it so that we can get a level of perspective that we might not otherwise have by really stopping for a moment and looking at this thing most critically. It's my pleasure to introduce our speakers for today. First, Fatima Afia, who was my student here at John Jay College of Criminal Justice. She's a summa cum laude graduate of the school. She became a paralegal at Hiller PC, and she is one of the rising stars in New York today. Also with us is Scott Waller, who was the valedictorian of his law school class, who is a senior counsel at Hiller PC and is one of New York's truly exceptional litigators. And my name again is Michael Hiller. I was a member of the faculty here from 2005 to 2013, teaching constitutional and criminal law and evidence. I'm also a mediator of the New York State Supreme Court. Today, we're going to cover three topics, and let's see if I can do this right. Here we go. So first, we're going to talk about basic information about impeachment and removal, and that's something I'm going to cover. Next, we're going to go through past impeachment inquiries of presidents, and that will include the trial of President Andrew Johnson, the impeachment inquiry of Richard Nixon, and then the impeachment and trial of Bill Clinton. And then we're going to discuss the impeachment inquiry of Donald Trump and the assorted aspects of that. And following that, we'll have a panel discussion. And my hope is that we'll have some back and forth and some real dialogue to talk about what it is that's going on and how we're supposed to respond to it. So first, let's talk about impeachment and removal. The good news is the Constitution has something to say about this. So first, Article 2, Section 4 says that the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. Now, those terms, we're going to talk about those in a few minutes. But first, we should talk about what the process is all about. First, the procedure. So the procedure under the Constitution is really not there. There's nothing in the Constitution that talks about who testifies first, what types of evidence is received. The burden of proof isn't even discussed. There's no burden of proof. Like you would think, when you think about the House of Representatives and impeachment, something akin to indictment, you'd think maybe probable cause is the standard. And at the Senate, where there's a conviction and a trial and a conviction or an acquittal, you think the standard might be beyond a reasonable doubt. But the truth is, none of those standards are listed in the Constitution, and the fact is that historically we haven't followed any of those concepts at all. Even though the words conviction and convict are actually mentioned specifically in the Constitution, beyond a reasonable doubt is not the standard. And with respect to the House of Representatives, even though impeachment is akin to an indictment, probable cause isn't the standard either. Now, during the Richard Nixon impeachment inquiry, there was a lengthy discussion about what standards should be applied. And ultimately, where we came down was that Gerald Ford actually said impeachment, and we'll get to this in a few minutes, but impeachment essentially is whatever the individual members of the House of Representatives decide it is. It's actually left to the conscience of each individual member of Congress. With respect to the Senate is the place where impeachment is tried. And so let's talk about that. It's interesting. Why did they pick the Senate to try, and why did they pick the House of Representatives to impeach? So it turns out that it's based upon the British model. In Great Britain, they actually have impeachments. And the impeachment process is in the House of Commons, which is like the House of Representatives, the People's House. and the House of Lords tries impeachments. In fact, the impeachment process is in almost every respect identical to the British model, except one very important one, and I'll get to that in a few minutes. When we talk about why the House of Representatives was selected, in addition to the fact that it's akin to the House of Commons, it was regarded as the people's chamber. And in the same way that grand juries, membership to the grand jury, has anyone ever sat in a grand jury before? Well, I'll tell you, it's a thin slice of heaven. You spend a lot of time in a room with prosecutors. They ask a lot of questions. You sit around for about 2 or 3 months, depending on how long your service is. In any event, the point is that grand jury service is drawn from the community. So someday you may receive a subpoena to sit on a grand jury, and you'll have to go through that process. In the same way, the House of Representatives is the people's chamber. So like a grand jury is drawn from the people, so too is the process by which we impeach a president. It is based upon the people's choice. With respect to the Senate, we can look to Alexander Hamilton, let's see, right here. And it's interesting because the way Alexander Hamilton saw the Senate is quite different from perhaps the way we would see it today. Where else than in the Senate could have been found a tribunal sufficiently dignified and sufficiently independent? What other body would likely feel confidence enough in its own situation to preserve unawed and uninfluenced the necessary impartiality between an individual accused and the representatives of the people, his accusers? And by the way, the capitalization is all of Alexander Hamilton's. That was Alexander Hamilton before he put on that great Broadway show. So the House impeaches, and the Senate conducts the trial. And as I mentioned earlier, there are really no standards that are applied. But I should know a little bit more about the process. So once impeachment articles are approved by either the House Judiciary Committee or the House Impeachment Committee, House managers are appointed. And those House managers become the prosecutors for the purposes of a Senate trial. And then at the Senate level, what we have is the Chief Justice of the Supreme Court, in cases of impeachment involving the President, the Chief Justice of the Supreme Court serves as the presiding officer. And that is essentially it in terms of what the rules are. Let's talk for a second now about the standards again for purposes of impeachment. I mentioned this earlier. It's conviction of treason, bribery, or other high crimes and misdemeanors. So what do those terms really mean? When we think of treason, we think of acts against the United States. But in point of fact, treason is considered to be different under the Constitution. The framers of the Constitution were deeply concerned that people in Congress would use the impeachment process as a basis to harm political opponents. So what they decided to do was to make it really raise the bar pretty high. When it comes to treason, Article 3, Section 3, treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. And what that means is you cannot be convicted of treason and impeached and convicted of treason if there's no active or declared war against an enemy state or an enemy organization. Now, for purposes of today's discussion, there has been some talk about how could you charge Trump with treason, and the answer is you can't, because we are not at war, either declared or otherwise, with Russia. So even though some people may feel that Donald Trump has done something that's treasonous, for purposes of the Constitution, he simply can't be impeached on that basis. But that's not the end of the inquiry, because as you can see, there's also, let's see if I can get this right, bribery or other high crimes and misdemeanors. Now, bribery, most people would think, when they think of bribery, they think of what it means under the statutes, under the New York penal law or federal law. But what most people don't know is at the time the Constitution was drafted and adopted, there was no federal bribery statute. There were no federal statutes at all, really. So what happened was, you really have to look to see what the Federalist Papers and what the contemporaneous writings of those who were involved in the creation of the Constitution, what they were really thinking. And for purposes of bribery, the understanding by the framers was that it really was derived from English law. Bribery was regarded as an abuse of power by a person in public office in order to obtain a private benefit rather than in the pursuit of the public interest. So that's the key element, placing private interests ahead of the public interests and accepting something or demanding something of value in return. That in and of itself is bribery for purposes of the Constitution. Now, high crimes and misdemeanors is a lot more complicated. How many people here have taken criminal law? That many. Okay, the professors have. That's a good thing. So for those of you but you probably know that misdemeanors doesn't sound quite as bad as a felony, right? When you think of a misdemeanor, you think of a petty offense. The truth is a misdemeanor is a crime that is punishable by less than a year in prison. So when you think about misdemeanors, you think, well, high crimes and misdemeanors, why are those two concepts together? Well, the truth is, though, the word misdemeanor today has a vastly different meaning than it had in the 18th century. And so I'm going to pull a tool out of the Scalia toolbox and actually go to a source document from the 18th century to see exactly what the word misdemeanor meant. Let's see. I don't know if I have a slide for this. Do I? Am I going the right way? Here we are. So back in the 18th century, misdemeanor was defined as a crime of a heinous nature next to high treason. Now that sounds a lot worse than misdemeanor sounds today, right? And that's because misdemeanors were really considered to be public crimes, heinous in the sense that it's like treason because it's a crime against society itself. And so that leads me to, again, Federal 65. And by the way, it's a great source document for purposes of understanding impeachment and removal. Alexander Hamilton said, and I quote, "The subjects of its jurisdiction," its meaning impeachment, jurisdiction, "are those offenses which proceed from the misconduct of public men, or in other words, from the abuse or violation of some public trust. They are of a nature which may with peculiar propriety be denominated as political, as they relate chiefly to injuries done immediately to the society itself." So we're talking about not just something that someone did wrong. It's something that someone did wrong that caused some sort of public injury, some real harm directed at society. But having said that, it's important to recognize that Hamilton and the other framers were deeply concerned, again, about the possibility of factionalism and partisanship. He was concerned, they were all concerned, that presidents would be subjected to this angry, sort of mob-like attitude towards those in power who were not favored by those outside of power. So he wrote, again, in Federal 65, in the very next sentence, which is not written up there, I'll just read it to you. "The prosecution of high crimes and misdemeanors will seldom fail to agitate the passions of the whole community and to divide it into parties more or less friendly or inimical to the accused. In many cases, it will connect itself with pre-existing factions and will enlist all their animosities, partialities, influence, and interest on one side or on another. And in such cases, there will always be the greatest danger that the decision will be regulated more by the comparative strength of the parties than by the real demonstrations of innocence or guilt." So when you think now about a lot of the discussions that people are having about whether or not impeachment should have gone forward, I'm sure you've all followed it to some degree. Should the Democrats do it? Should they not do it? Why would they bother doing it given that the Senate is currently controlled by Republicans, and right now the Democrats don't even have a majority, much less the 2/3 necessary to convict. So the whole thought process is, how can we possibly get that outcome? And ultimately what you come down to is that people who are interested in whether or not to convict or to acquit should always remember one thing, and that the Constitution itself does not really talk about politics. It talks about obligation. It talks about duty. And so the real question comes down to is whether or not in the Senate enough people come to the belief that they have no choice but to vote in favor of conviction or acquittal based upon what they perceive to be their constitutional obligations. And lastly, I would just refer you to the words of Gerald Ford, who I mentioned earlier. Gerald Ford has the distinction of being the only president to assume that office after someone else was forced to resign. And Gerald Ford said, and I quote, this is back in 1970, I believe the impeachment involved, the inquiry involved William O. Douglas, who was a Supreme Court justice at the time. He said, an impeachable offense is whatever a majority of the House of Representatives considers to be at a given moment in history. And that's pretty much where we are today. The real question is going to be whether or not the House of Representatives, in the context of the impeachment inquiry of Donald Trump, believes that at this moment in history, what he has done meets the constitutional definition for impeachment, specifically whether he has committed the crimes of treason, which he clearly has not, bribery, or high crimes and misdemeanors. It's against that background that I'm going to ask our next speaker, Scott Waller, to address the issue of Andrew Johnson's impeachment, as well as the Nixon impeachment inquiry, and that will be followed by a discussion led by Fatima Afia and Bill Clinton. And after Scott speaks, I'm going to open the floor to some questions. We'll take 5 minutes of that. Then after Fatima speaks, another 5 minutes or so of questions, and then we'll continue towards the panel discussion. Thanks a lot. Yeah, let me help you out there. I'm an expert now.
All right. Thank you, Michael. All right, so Andrew Johnson, those constitutional principles that Michael just discussed were first put to the test in 1868, when Andrew Johnson became the first U.S. president to face impeachment. Did I do this wrong? Oh, sorry.
Left goes forward, believe it or not.
There's a nice little stock photo of Andrew Johnson. So who was Andrew Johnson? He was a Southern Democrat from Tennessee who's twice elected governor of that state, and he was elected to the Senate from Tennessee in 1857. What's that? Okay. Can y'all hear me? Yeah? Okay. I hate being too close. And then,
Don't worry.
if you can't hear me, just, holler. I'll speak up. Yeah, okay. The cameraman needs me to speak up, so okay. So again, he was a Southern Democrat from Tennessee, and he was elected senator in 1857. At the time, as you may know, many Southern states, including Tennessee, were contemplating secession from the Union. And even though he was a Southern Democrat and he was a slave owner, he actually opposed secession and was a strong supporter of the Union. And his support of the Union endeared him to the Northern Republicans, including Abraham Lincoln, who became president in 1860. And in 1862, when the Union took control of Tennessee, which had seceded from the Union, Lincoln rewarded Johnson by naming him as the military governor of Tennessee. And then 4 years later, when Lincoln was running for re-election, he rewarded Johnson again by choosing Johnson as his running mate. Of course, Lincoln was re-elected, and he was sworn in early 1865, and Johnson was sworn in on March 4th, 1865. And just 42 days later, Lincoln was dead, and Johnson became president. So how did we get to the impeachment of Andrew Johnson? When he became president, the Civil War had just ended, and Reconstruction had begun. And the northern states and a lot of the northern Republicans had started to pass several laws that would, among other things, give citizenship and give equal rights to freed slaves. Johnson opposed those measures. He vetoed 2 bills, in fact, that would have, among other things, provided full citizenship, voting rights to freed slaves. One was the Civil Rights Act. Another was the Freedmen's Bureau Act. Among other things, Johnson also pardoned many Confederate leaders. Of course, all of this angered the Northern Republicans, who had previously had felt very favorably of Andrew Johnson. He also imposed governments on some of the former Confederate states that, so these southern governments in some of these states were run by ex-Confederates and also were passing their own laws to restrict the rights of freed slaves. So because of that, the House actually tried to impeach Johnson twice and failed. So eventually they decided to set a trap, and they passed what's called the Tenure of Office Act. And essentially what this act said was that a president cannot appoint or remove officials from his cabinet without Senate approval. putting aside the fact that it's probably unconstitutional, it was specifically designed to entrap Johnson and lead to impeachment. In fact, Article 9 of that statute provided that any person who violated the act would be guilty of a high misdemeanor. Johnson eventually took the bait, and and because Johnson became president only 42 days after Lincoln was assassinated, most of his cabinet were Lincoln appointees, and there were several that Johnson wanted to remove. And one of them was the Secretary of War, Edwin M. Stanton. Stanton opposed many of Johnson's Reconstruction policies, and Johnson was also, Stanton as Secretary of War was head of the military. The military at the time was sort of like an occupation force in the South. They were in charge of keeping the peace, especially at the polls, making sure people could vote, especially freed slaves. So he clashed with Johnson. Johnson wanted him out, and eventually Johnson fired him. And in doing so, he violated the tenure of office act. Sorry. So with the firing of Stanton and the violation of the Tenure of Office Act, the House finally had a basis to impeach him, and eventually the House drew up 11 articles of impeachment. The first 9 were essentially alleged that Johnson violated the Tenure in Office Act. They were basically the same charge. A 10th accused Johnson of making inflammatory and intemperate speeches in a loud voice, among other things, which is kind of silly, but it did pass. And the 11th article accused Johnson of violating a number of acts and also questioning the legitimacy of Congress. Eventually, so those 11 articles passed the House, and so the impeachment inquiry moved to an actual impeachment trial in the Senate. And that began on March 5th, 1868. It was the first presidential impeachment trial in history. And interestingly, the Senate actually decided to only vote first on the 11th article of impeachment. And they did that on May 16th, 1868. And the vote was 35 to convict to 19 to acquit. That was one vote short of the 2/3 majority needed to convict Johnson. So falling short, they then moved to the second and third articles of impeachment. And those were voted on and had the same result, 35 to 19. After that, they gave up and Johnson was acquitted. So he was really acquitted based on one vote. And there's a lot of talk about bribery and that many of the senators who voted to acquit actually received large sums of money and some other political favors to vote to acquit. So it's interesting. But at the end of the day, what do we learn from the Johnson impeachment? There's not much comparison to the current impeachment of President Trump or the current impeachment inquiry of President Trump. It was largely a political matter and a political infight between the executive and Congress that opposed the direction of Reconstruction. One interesting point, though, with the removal of Stanton, like I said, was the head of the Army. The Army was in charge of keeping the peace in the southern states, and in that regard, they were in charge of ensuring that freed slaves could vote. And in 1868, Johnson was planning to run for re-election, and he did not want Southern freed slaves to vote because they would not be voting for him. So in a sense, you could say that by firing Stanton, he was acting for his own personal benefit as opposed to the benefit of the public, which sort of ties into what we're seeing with Donald Trump, particularly with the allegations of the quid pro quo in the Ukraine to investigate a political opponent for his personal gain. The next time we got to impeachment of a president was about 100 years later, and exactly 100 years later, Richard Nixon was elected President of the United States in 1868. And you see a quote there that I put up. This is a quote from Richard Nixon to White House Chief of Staff H.R. Haldeman. It was June 23rd, 1972, and this was 5 days after the famous Watergate break-in, which sort of led to the whole impeachment inquiry. And he said, "Call the FBI and say that we wish, for the country, don't go any further into this case, period." That sort of encapsulates what the whole Nixon inquiry was all about. And I'll get to it, but it really was about a cover-up of a crime. And when this quote came out, when this was released, the tape was finally released, 5 days later, Nixon resigned. The quote is from 1972, but the public didn't know about it until 1974. So when it was finally revealed, the extent that he was involved with covering up Watergate, just a few days later, he was gone. So there's Nixon, another nice stock photo. So again,
the best picture of Richard Nixon I've ever seen.
I was trying to look for one that wasn't so good, but this is what I could find. I'm sorry. Nixon was the 37th president. He took office on January 20th, 1969, and he ended up resigning on August 9th, 1974. Nixon was a Republican member of the House and a senator from California, and he was Eisenhower's vice president from 1953 to 1961. In 1960, he ran for president against John F. Kennedy and lost. He then ran to be governor of California, and he lost. And in 1968, he decided to run for president again, and what do you know, he won. And in 1972, he was actually elected by one of the largest majorities in history. He only lost one state, and that was Massachusetts. And this was after the Watergate break-in. So, Watergate, where it all began. Oh, sorry. I'm not keeping up with the slides. So, Watergate, where it all began. In 1971, Nixon created what was known as the White House Plumbers. It was a special unit with some interesting characters, and they were tasked with stopping and responding to leaking of classified information. And this was prompted by the leak of the Pentagon Papers, which was a classified history of the Vietnam War. And Nixon wanted to investigate the leaker, so he created this group, and they were led by a former CIA operative, E. Howard Hunt, and a former FBI agent, G. Gordon Liddy. In 1972, in summer of 1972, in the midst of Nixon's re-election campaign, it decided to break into the offices of the Democratic National Committee, which was located in the Watergate complex, and tap phones and steal documents. Unfortunately, the wiretaps that they placed in the offices didn't work. So on June 17th, 1972, they broke in again to replace the wiretaps. And by chance, a security guard who was working at the complex noticed the burglars, and notified the police. The police arrived and arrested 5 burglars. Hunt and Liddy were sort of the leaders of the group. They were later discovered to be directing them by walkie-talkie from a nearby building, and they were later arrested as well. So the investigation. Shortly after the arrest, there were some suspicion that the White House was involved, particularly because one of the burglars was on the payroll of Nixon's re-election committee. And this was discovered by Bob Woodward and Carl Bernstein, reporters of the Washington Post. So they began an in-depth investigation into the Watergate break-in and discovered a lot of interesting things and a lot of connections to Nixon. One of them, like I said, was that one of the burglars was on the payroll of Nixon's re-election committee. In addition, they discovered that a grand jury at the time was questioning Hunt and Liddy, who were known to have worked in the White House with Nixon. And again, like I said, they would later be indicted and arrested with the 5 other burglars. They also discovered that a $25,000 check for Nixon's reelection had been deposited into the bank account of one of the burglars. In addition, Attorney General John Mitchell, they discovered, controlled a secret fund that paid for a campaign to gather information on Democrats. And lastly, they discovered that Nixon's aides had run a massive campaign of political spying and sabotage, like I said, led by the group known as the Plumbers. Nixon, of course, denied any involvement, and later that year, in November, he won, like I said, one of the largest landslides in American history. He won re-election by a landslide. In January 1973, the burglars and Hunt and Liddy, some of them, 5 of them, pleaded guilty. 2 went on trial and were convicted of the Watergate break-in. And after that, the cover-up starts to unravel. In February of 1973, the Senate established a select committee on presidential campaign activities, the purpose of which was to investigate the events surrounding the Watergate burglary. And then in April 1973, one of the burglars told the U.S. District Judge John Sirica, who had presided over the trial of the burglars, that he was being pressured to remain silent. And all of this stuff was starting to become public. And later in April 20th, the FBI director, Gray, resigned after he admitted to destroying evidence at the request from the White House. And then 10 days later, 4 of Nixon's top officials resigned. And then in May 17th, the select committee that was established in February began its public hearings. And in those public hearings, the former White House counsel, John Dean, testified that there was ongoing White House cover-up of Watergate, and he admitted to paying hush money to some of the burglars. And then another official revealed that Nixon had actually recorded all his conversations in the Oval Office. And this was a significant revelation, and this sort of which really led to, as you'll see, one of the impeachment articles. Because when it was discovered that there were recordings of Nixon's conversations, the committee, of course, wanted them and issued subpoenas. And also, there had been a special prosecutor, Archibald Cox, appointed to investigate the Whitewater break-in, and he issued subpoenas to Nixon for those tapes as well. But Nixon refused, and he would not turn over the tapes. Instead, he ordered his attorney general to fire Cox, and his attorney general refused and ended up resigning. And then the same day, he ordered the deputy attorney general to fire Cox. The deputy attorney general refused and resigned also. So eventually, someone did fire Cox, and that was Robert Bork, who you may know ended up being appointed to be a Supreme Court justice in the 1980s by Ronald Reagan, but was not. It was voted down by the Senate. Anyway, that day became known as the Saturday Night Massacre. And this gets us to the actual impeachment. Nixon's continued refusal to turn over the tapes in response to the subpoena, this time from the new special prosecutor, Leon Jaworski, led to a Supreme Court decision in the case United States v. Nixon on July 24th, 1974, in which the unanimous Supreme Court rejected Nixon's claim of absolute privilege and ordered that the recordings be turned over to the special prosecutor. Just 3 days later, the House Judiciary Committee approved the first article of impeachment against Nixon. A few days later, they approved 2 more articles of impeachment. 2 additional articles were considered, but they were voted down. I'll just quickly summarize the articles of impeachment against Nixon. The first was obstruction of justice. This is the first article, charged Nixon with obstruction of justice in connection with the various investigations of the Watergate burglary. According to Article 1, Nixon, among other things, misled investigators, withheld evidence suborned perjury, approved hush money payments to Watergate defendants, and lied to the American people about his own involvement in the scheme. Thus, Article 1 concluded that Richard M. Nixon has acted in a manner contrary to his trust as president and subversive of constitutional government, to the great prejudice of the cause of law and justice, and to the manifest injury of the people of the United States. The second article was, and this, of course, was, derived from his refusal to comply with the subpoenas from the committee and also from the special prosecutor. Article 2 charged Nixon with the abuse of power, and among other offenses, Article 2 alleged that Nixon sought to have political enemies audited by the Internal Revenue Service, ordered FBI wiretaps for political purposes, unrelated to any lawful function of his office, authorized a secret investigative unit, the Plumbers, to engage in covert and unlawful activities, and knowingly misuse the executive power by interfering with agencies of the executive branch, including the FBI and the CIA. And lastly, the third article approved by the House Judiciary Committee was contempt of Congress. It accused Nixon of having failed without lawful cause or excuse to produce papers and things as directed by duly authorized subpoenas. Again, as a result of Nixon's refusal to comply with subpoenas. Before the full House could vote on those three articles of impeachment, on August 5th, 1974, Nixon had released the recordings in response to the Supreme Court's decision. He'd released the recordings of his conversations in the Oval Office. But there was one that he withheld. And then on August 5th, 1974, he finally released which was known as the smoking gun tape. And this is where that quote, and this is where that quote that we saw earlier came from that recording. It was, like I said, 6 days after the Watergate break-in, and it made clear that Nixon was deeply involved and ordered the cover-up of the Watergate break-in. And after that, Nixon realized that he had no support in the Senate. The House was going to impeach, and so several days later, he resigned, becoming the first U.S. president to resign from office. That's it.
Thanks, Doc. Whoops. So I want to make sure we get back to this page because it's the first time I've looked at this in a long time. But if you look at the articles of impeachment, particularly Articles 2 and 3, they definitely have a certain amount of relevance to what's going on today. In any event, we'll get to that in a little bit. But first, we need to hear about the salacious details of the Bill Clinton impeachment. And who better to talk about that than Fatima Afia of my office. Fatima Afia, ladies and gentlemen.
Thank you, Michael. There we go. Okay. So, 1998. It was a memorable year for lots of reasons. The New York Yankees won their 24th World Series. Furbies were all the rage. Nokia phones were extremely popular. The movie There's Something About Mary came out that year, and Seinfeld aired its last episode. But 1998 was also extremely memorable for one important reason. Sorry, I need to get the hang of this. And that is because the 42nd president of the United States, the second president ever in U.S. history, was impeached by the U.S. Congress. Now, the 42nd President of the United States, as many of you might know, is President Bill Clinton. Just to give you a little bit of a background on who Bill Clinton was, he was born in Hope, Arkansas, and he had attended Yale University, where he obtained his law degree. That's also where he met his wife, Hillary Rodham Clinton. Some of you may know who she is. And after getting his law degree, Bill Clinton became the professor of law at the University of Arkansas. He worked there for about 2 years before he then ran under the Democratic ticket as the state attorney general. He worked in that capacity for about 2 years before running for governor of Arkansas, and he won 5 out of 6 consecutive elections that he ran between 1978 and 1990. In 1992, he then decides to run for President of the United States against George H.W. Bush. Now, there's really not many similarities between the circumstances of the impeachment of President Clinton and the current impeachment inquiry that's going on regarding the Trump administration. However, there is one important thing that both of these administrations have in common, and that is that the circumstances in Washington were very volatile in terms of partisan politics. Republicans and Democrats did not get along during the 90s. There was a lot of anger on both sides, and a lot of this stemmed from a promise that President George H.W. Bush had broken before he lost his election to Bill Clinton, and that was that he was not going to raise any new taxes. But he decided to make a peace deal agreement with Democrats in Congress and passed legislation that in fact did raise taxes. Republicans were not happy with him. That's partly why a lot of political analysts say he lost the election to Bill Clinton. And when Clinton came into office, Republicans were mad that this was the first election in decades, the first presidential election in decades that they had lost. And they were mad at the promise that had been broken by George H.W. Bush. And so they were hell-bent on doing anything they could to interfere with Clinton's agenda. They did not want a liberal agenda. And so, in fact, one of the big policies put forward by President Clinton during his first term was he wanted to pass health care reform. Him and his wife worked on it for years, and their own party, the Democratic Party, worked against them for years. Health care reform ended up failing, so when the midterm elections happened in 1994, the Democrats lost many seats. Republicans took control of both the Senate and the House of Representatives, leading all towards a perfect storm for impeachment of a president who the party in control did not like. Adding to the control that the Republicans now had of both houses of Congress was the fact that the Clintons had already been disliked by Republicans in Washington, and so there were a number of ongoing investigations by the Office of Independent Counsel. The Office of Independent Counsel is effectively where a special prosecutor like Robert Mueller would work, and he was assigned to investigate the Clintons on a number of different supposed scandals that they were involved in, one of which was Whitewater, involving a real estate venture in Arkansas that the Clintons had been associated with. There were claims that there were fraudulent transactions occurring with Whitewater, and so there was an investigation going on regarding whether the Clintons were involved in those fraudulent transactions. In relation to that, a White House deputy of counsel named Vince Foster died shortly thereafter, and there were claims that there were files relating to this Whitewater investigation in his office. They said that his death was mysterious. It had been ruled a suicide, but they claimed that it didn't really make much sense, that it must be a cover-up, that there was a homicide going on. So the Clintons were being investigated for both Vince Foster's death, the Whitewater scandal, and so there was already an ongoing investigation into their lives. Add to that, in 1994, a woman by the name of Paula Jones files a lawsuit against President Bill Clinton accusing him of sexually harassing her. She was a state employee in Arkansas, and she says that in 1991, President Bill Clinton, who at the time was the governor, had propositioned himself to her in a hotel room, and that she had been emotionally distressed as a result of that she had been denied her civil rights because there were women who had supposedly taken his advances and had been able to move up in their careers, and that she was basically slighted in her career for refusing his advances. And so it's not until 1997, though, that Clinton actually has to really defend against this lawsuit, because he goes to the Supreme Court and he says, there's presidential immunity. I'm a sitting U.S. president. I can't be bothered with having to go back and forth with this lawsuit, going to court. This is going to get in the way of my presidential duties. And up until that point, a U.S. sitting president had never been sued for actions unrelated to his conduct in office. So this was an unprecedented case, And in Clinton versus Jones in 1997, the US Supreme Court decides, well, you're not being sued because of anything involving your presidential responsibilities. There's no reason why someone else can't go on your behalf to trial. You can be sued for actions that have nothing to do with your presidential capacity. And so that marks the beginning of the road to impeachment. So in this picture, you will see President Bill Clinton, and to his left is Monica Lewinsky. Monica Lewinsky was a 22-year-old intern who started working at the White House in 1995. And she claimed and was telling a friend of hers named Linda Tripp about her sordid sexual encounters with the president. According to her, this relationship began in November 1995 during a government shutdown, and she did not know, unfortunately, that as she was telling this woman by the name of Linda Tripp, that all of her conversations were being tape recorded. This all happened after Monica Lewinsky left the White House in 1996, where she went to go work at the Pentagon. And Linda Tripp was a civil servant at the Pentagon. They became friends, although if that's a friend who tape records you secretly about your most personal and intimate conversations, then I don't know, I wouldn't want you as an enemy. And so for months, this woman is tape recording everything that Monica tells her about her relationship with the president. And interestingly, Monica was actually transferred to the Pentagon in 1996 because a White House aide became uncomfortable with the closeness that she perceived between the president and Monica Lewinsky, and she had her transferred out. So Monica is now talking to Linda Tripp about how upset she is that she's not in the White House anymore, that she misses the president. She's telling her all these things, and little does she know, everything that she's saying, about 20 hours worth of conversation, is all being recorded by this woman who clearly has an agenda. So now Linda has dozens of tapes of everything that Monica's been telling her. She decides she's going to start handing them out to anybody who will listen. So she sends over copies of the tapes to the counsel for Paula Jones in the lawsuit that is pending against President Clinton. She also sends them over to Kenneth Starr, who is the special prosecutor in the Office of Independent Counsel, where the Whitewater investigation is taking place against the Clintons. And, she hadn't gotten enough of sending out these tapes, almost like Oprah giving out, free things, except she's just giving out tapes of people's private conversations. She also sends copies over to a reporter at Newsweek by the name of Michael Isikoff. After this, Kenneth Starr, the special prosecutor, listens to the tapes, becomes intrigued, and around the same time, the attorneys for Paula Jones in the lawsuit, after also listening to the tapes, now put Monica Lewinsky as a witness on their list in the lawsuit because they're trying to make a case that in addition to their client being harassed by the president, there's also a work pattern behavior of sexual abuse going on. And so they put Monica Lewinsky on the list, they subpoena her to testify, and also they subpoena records of any of her communications with the president. So at this point, Monica Lewinsky is not willing to share with the public what's been happening in her personal life. She files an affidavit, which is a sworn statement, with the attorneys in the Paula Jones lawsuit. And in that affidavit, she explicitly says that there has never been any contact or sexual relationship whatsoever between her and the president. So when Kenneth Starr, the special prosecutor, hears the tapes in which she's clearly admitting, graphically in some cases, about her relationship with the president, he knows that she has now perjured herself and that there's something there, and that the president most likely will not be admitting to any of the things that have supposedly happened in this relationship. And he figures, I haven't been successful in all of these investigations I've been wasting taxpayer money on for years, so this is it. This is how I win. So on January 17th, 1998, Clinton is deposed in the Paula Jones lawsuit. And as he's being questioned, he makes explicitly clear and denies any sexual relations, any sexual relationship, or any affair with Monica Lewinsky in those exact terms. And during that lawsuit, the lawyers for Paula Jones had defined sexual relations in a very narrow manner. They had defined it as any knowing contact between yourself and the other person's certain body parts, including genitalia, breasts, so forth. And so Clinton claims there was never any sexual relations, never any sexual relationship, and never an affair with Monica Lewinsky. This is what he says. A few days later, he goes on national television and now says the infamous line that everybody knows from this ordeal, which is that I did not have sexual relations with that woman, Miss Lewinsky. Now Kenneth Starr knows, okay, this guy is clearly not telling the truth about what's happening between him and this former intern. This is it. He tries to get Monica Lewinsky to cooperate, to testify before a grand jury in his investigation. She doesn't want to cooperate. So what does he do? He goes to her mother. He forces her to testify. She testifies for over 3 days, and they then badger her about a supposed garment, a piece of clothing that has a stain of the president's semen on it. This is information that is relayed to Kenneth Starr by Linda Tripp. And so when they ask Monica Lewinsky's mother about this supposed garment, accusing her of hiding it, she initially refuses to talk about it. But after 3 days of wearing her down, she finally admits to having this garment. It is now what everyone refers to as the blue dress. Monica Lewinsky's mother is eventually forced to turn over this dress to Kenneth Starr. The dress is tested for DNA. It is matched against a blood sample that's taken from the president, and it is confirmed that the semen does in fact belong to the President of the United States. So, in August 1998, after reaching an immunity deal with Kenneth Starr's team, because Monica Lewinsky was being threatened with being prosecuted for perjury for the sworn statement she had submitted saying that there was no relationship, she now agrees to testify before the grand jury. And during that testimony, she states that during her 18-month consensual relationship with the president, she had performed oral sex on him numerous times, and he had touched her supposedly on numerous body parts. In that same month, the president voluntarily agrees to testify before a grand jury, but he does so under only certain conditions. He wants it to be a closed-circuit television testimony, meaning that it's just him and the person that is asking him the questions, the attorney, and that the actual grand jury will be watching through a TV. And he wants his attorneys present, which typically is not allowed for a grand jury proceeding. And he also wants it to take place at the White House. So this grand jury testimony ends up being televised to the entire public. And during his testimony, he now acknowledges for the first time that he had inappropriate, intimate contact with Monica. But he maintains that his prior denial that he did not have sexual relations with Monica is true, and that he did not lie when answering the questions that were asked of him in his deposition in the Paula Jones lawsuit. On September 9th, 1998, Kenneth Starr submits a 445-page report to Congress laying out 11 legal grounds for impeaching the president and detailing a sexually graphic narrative pertaining to the president's sexual encounters with Monica. The report is released to the public just 2 days later. In October 1998, the House of Representatives votes to begin impeachment proceedings. The House Judiciary Committee decides that it's going to focus on two main allegations, which is perjury and obstruction of justice. On December 19th, 1998, the House of Representatives votes to impeach the president under two articles of impeachment, one for perjury during the president's grand jury testimony, in which he said that he did not have any sexual relations with Monica and that his prior deposition testimony was accurate, and the other article is for obstructing justice during the Paula Jones lawsuit. Both articles of impeachment were passed along party lines, with Article 1 for perjury passing by 228 members in favor of impeachment and 206 opposed. And then Article 3, which was for obstruction of justice, passed by 221 in favor and 212 opposed. Okay. So we're going to break down the two articles just a little bit. So Article 1 is for perjury, and it was brought under the high crimes and misdemeanors sort of catch-all under the Constitution. For perjury, to prove perjury, you have to show that the person knowingly made a false statement pertaining to a material fact under oath. In his grand jury testimony, Clinton stated that he did not have sexual relations with Monica as he understood that term to mean. In his mind, he was saying sexual relations to him means sexual intercourse. And even as Monica had admitted during her testimony, there was no sexual intercourse. He also says that even under the definition posed by the attorneys for Paula Jones during that lawsuit, which was a very narrow definition, it did not include oral sex performed on him. Because the definition, again, do I have it here? Oh, yes. When a person knowingly engages in or causes contact with any one of a number of enumerated private parts of another. So Clinton was arguing that because the oral sex was performed on him and that he had not performed anything sexual on Monica, it did not fall within the definition as prescribed by the lawyers for Paula Jones. And because there was no sexual intercourse, which is what he understood sexual relations and sexual relationship and affair to mean, he did not lie during his deposition, and he did not lie during the grand jury. That was his defense. Starr's argument, and the legal team for Starr say that, well, based on DNA evidence on the blue dress, based on Monica's very detailed narrative of your encounters with her, based on your own admission that there was inappropriate intimate contact with her, we don't believe that your definition of sexual relationship would be that narrowly tailored. We don't believe that that's the truth. But as we all know, it's hard to prove what someone genuinely believes, and that's basically what the attorneys for Clinton said. You're not going to be able to prove before the Senate, if you were to go to trial, that I didn't actually believe that this is how I define sexual relations or sexual relationship. Article 3, which is for obstruction of justice, also under the catch-all high crimes and misdemeanors, is generally defined as intentional interference with the orderly administration of law and justice. Starr's claims were that Clinton instructed Monica to submit a sworn statement in the Paula Jones case, falsely denying a relationship between them so that she could avoid testifying at the deposition in the Paula Jones matter. Starr also says that Clinton coached Monica on cover stories about their time together if she were called to testify in the Paula Jones deposition. And Starr also claims that Clinton helped Monica land a new job in New York in order to secure her silence in the Paula Jones lawsuit. In his defense, the president argued that although he mentioned the possibility of filing a sworn statement to avoid testifying, he never told her to make a false statement. He says, his team says, that the reason he told her to file an affidavit to avoid testifying is that presumably she could have just said she had never been sexually harassed by the president, and so therefore none of her relationship with the president was relevant to the underlying accusation in the Paula Jones lawsuit, which was sexual harassment. Because according to Monica Lewinsky, throughout this whole ordeal, everything that happened between her and the president was completely consensual. And then another defense of the president's is that any cover stories that he may have discussed with her on multiple phone calls was all prior to her being put on a witness list for the Paula Jones case, and that it had nothing to do with trying to avoid the law or interfere with legal processes, that any cover-up stories was completely personal, just to protect their own privacy and to avoid any humiliation or embarrassment. And then lastly, he puts forward a defense that his assistance in helping Monica secure a job in New York, which he ultimately helps her secure, was actually a process that began long before she was put on this witness list in the Paula Jones matter, that he was helping her because she asked as a friend, and she's the one that came to him asking for this help because she was unhappy working at the Pentagon. The Senate trial begins in January 1999. It lasts about 5 weeks long, and at the trial, the President's counsel argues that although morally reprehensible, his conduct did not rise to the level of an impeachable offense, as it concerns only his private life, not his fitness to be president. On February 12, 1999, the Senate acquits Clinton, mostly along party lines, 55 in favor of conviction, 45 against, with regards to the perjury charge, and it's a 50-50 split with regards to obstruction of justice. Now, as Professor Hiller mentioned earlier, in order to get a conviction out of the Senate, you need 2/3 majority, which means 67 senators out of the 100. So clearly, they were well below what they needed. I think at least 10 of the senators who did not vote to convict were actually from the Republican Party. Despite the impeachment saga, Clinton's popularity continues to surge throughout his presidency, and he ends his last term with a 66 approval rating. But the Paula Jones and Lewinsky scandal continues to haunt the Clintons, as Hillary Clinton saw during her 2016 bid for presidential election. And now, just a couple of follow-up questions. Who here thinks Clinton should have been impeached for perjury relating to private matters? Nobody. Anyone want to answer why? You look like you're like on the fence. Well, according to him, he did it. It's a semantics argument, right? Do you buy his semantics argument? Does it matter that it's relating to his private life and not relating to any official conduct or his ability to actually be a fit president? Say that again?
The allegation was that a lot of the sexual relations took place in the Oval Office.
They did, although the articles for impeachment that actually passed were solely focusing on the fact that he perjured himself in relation to this relationship and that he then obstructed justice. There were actually no articles of impeachment that passed the House that were relating to just a general abuse of power. Anyone think that he should have actually been brought up on a charge for abuse of power, given the fact that she was an intern and he was the President of the United States? If this was brought today, I think, yeah. All right.
Paula Jones, by the way.
Say that.
So was Paula Jones.
Yeah, absolutely.
So the success, I think, was a pattern. I still don't think, I think it was much more of a political impeachment than.
Oh, absolutely. But I do think that if it was brought today, it would be a little bit less political and more about worker environments and, hostile work environments and women's rights. So, thank you.
Okay, we're running a little short on time, so I'm going to try to fly through as best I can the Trump stuff. So let's just talk very quickly about, let's see if I can do this right here. Okay, great. So with respect to Donald Trump, I'm going to try my best not to editorialize because I really want to leave that to the panel. But there are basically 4 areas of impeachment with respect to the Trump administration. The first one, and I'm going back in time a little bit, it seems like it was forever ago that we were talking about the Mueller report, right? And was there obstruction? Was there collusion or some sort of coordination? Well, there certainly was. I can tell. Has anyone actually read the Mueller report? Tell me the truth. Anybody? All right. I got to tell you, so 4 people in the room have read the Mueller report. That probably represents 4 out of the 7 people in the United States who have actually read the Mueller report because most members of Congress have not. I have read it. And I can tell you that it's worth reading if you want to see whether or not there was coordination. There is a lot of evidence in there on that subject. But in any event, the allegation is that there was a coordination between the Trump campaign and Russian operatives to hack the DNC and Hillary Clinton's servers, to help spear phishing campaigns, as well as to influence social network campaigns, and then and coordinate on the issue of political opposition research. And lastly, but no less importantly, there is a substantial question as to whether or not the Trump administration has eased back on Russia with respect to issues like sanctions and potentially for political payback for the assistance that Trump received during the election process. The second issue that he may be able to, that they're looking at for purposes of impeachment, is obstruction of justice with respect to the Mueller report. I can't go through all 10 of them, but there are at least 10 instances where the Mueller report refers to potential obstruction of justice by members of the Trump administration, particularly by Donald Trump himself. I'll just give you a couple of examples. You can see them on the board here. Donald Trump on national television acknowledged that he fired FBI Director Comey in an effort to quash the investigation. He also directed an assortment of individuals to cause Jeff Sessions, or to attempt to cause Jeff Sessions, to unrecuse himself because he regarded Jeff Sessions as somebody who would be more favorable to him. And one thing that's not up on the board, but which is important as well, is that at one point the prospect of dangling a pardon to Michael Cohen in an effort to influence his testimony was also conveyed to Michael Cohen's lawyers. The question is, of course, did Donald Trump obstruct justice? There's a whole separate issue on emoluments, and unfortunately we don't have time for that, but that has not gotten to Congress right now. Emoluments clause, basically, there's several of them in the Constitution, but the one that's most significant is the one that prevents the president from accepting gifts or other benefits from foreign emissaries or foreign governments. And in this instance, there is a substantial allegation that the President of the United States, having hotels and resorts around the world, is accepting foreign benefits. Specifically, foreign governments are patronizing his hotels and paying full freight on how much it costs to rent a room, and so he's making money, and that may be a violation of the emoluments clause. The last one pertains to the Ukraine, something that we're living through right now. And the question is really, number one, did Donald Trump ransom congressionally approved military aid in exchange for a promise by the president of Ukraine to announce an investigation, not necessarily, by the way, to undertake that investigation, just announce the investigation of Joe Biden, someone he regarded as a significant political rival, someone he thought could beat him in the election of 2020. Didn't Trump attempt to ransom congressionally approved military aid? Number one. Number two, what's the story with obstruction of justice? Has he coordinated with other members of the White House staff to avoid testifying before Congress? Has there been witness intimidation? And has he been inappropriately secreting files? The recorded telephone call and the transcript of that call were placed on a classified server, even though it's general common knowledge in the White House that none of the material on that file was in any way classified. So I want to open up the floor to questions, and I know there are some professors here. You can step up if you'd like, or you can take these questions from your seats. I want to first throw a question out to all of you. I can see there's an anxious person back there. That's great. The first question I wanted to ask all of you is, do you think the House should impeach, even under circumstances where the Senate is unlikely to convict? So first I'm going to turn it to the professors who have generously given us their time today. Professor, I don't know your last name. Your first name is Ian, but I don't know your last name. Professor Heller. I'm Professor Hiller. Professor Heller. Professor Heller, what do you think about whether or not should the House of Representatives impeach the president under circumstances in which, at the moment at least, politically, it does not seem that conviction is likely in the Senate? What do you think?
I can't imagine asking a grand jury if they think that they should indict a criminal based on whether or not a jury will convict him. The point of the grand jury is the point of the grand jury is to determine if there is sufficient evidence to go forward with a criminal trial, and that's what the point of the House is. I don't care what they think is going to happen. That's not in their purview. It shouldn't even be a discussion.
What do you guys think about that? How many people, just by showing of hands, how many agree with Professor Heller's analysis there? Does anybody disagree? He just won the first impeachment vote of 2019. Congratulations, Professor Heller. Let's see, we have the microphone there. I don't know if you could just take it over there. Oh, there's a question back. Wonderful. The gentleman in the vest. If you could just tell us your name first and grab that mic. What's your name?
I don't think I need this, but anyway. How you doing? My name is Professor Rafael Heredia from Department of Public Management. Oh, okay, very well done. As a federal law enforcement officer, I'm glad you brought up Vince Foster. I was in D.C. back and forth, ran the academy, and one of the things there is that the U.S. Park Police blotched the investigation during the Vince Foster. And so the conspiracy theorist made an issue because that the FBI did not want to assist in the evidence at the time, and there was just some issues that they were not equipped to process. So the conspiracy theorists made a whole bunch of stories there, but it was a very interesting jurisdictional issue. The United States Park Police won because they were founded with the country, 1791, and there's some clause with the United States Park Police that they have jurisdiction over properties. In this case, it was a park, Vince Foster. Anyway, I love this one. Hearsay. In the rules of evidence, every single individual that's testified under Trump says they never spoke to him. It's all hearsay. So under the rules of evidence, which will go into the Senate, heard by the Supreme Court Justice, the Chief Justice, if they follow the rules of evidence, which they will, in a hearing-type, trial-type judiciary system, no witness there is direct witness so far. So far, the only strong one that I say they may have is Lieutenant Colonel Vindman. Other than that, it is all hearsay. It's inadmissible. So today, that the Foreign Affairs, they don't have to follow the rules because they're under Foreign Affairs. When it hits Judiciary Committee, then we can actually, I would love to have this again.
Well, interesting question.
So now the question here is, does any of this relate into correlation to any of the previous impeachments that we've had? And the argument is no, because it's all hearsay. There is no real legality here.
Well, you know, it's interesting. There have been witnesses, thank you for that question. There have been witnesses who have testified so far to having overheard him over the telephone, giving instructions. In fact, today, there was a witness who testified that the president said, I don't care about the military. I don't care. What I care about is the investigation and getting the announcement. And he actually specifically directed that the investigation be announced on CNN. He actually identified the network. You know, it's interesting. I understand your point, which is what rules of evidence will be applied in a Senate trial. And as I mentioned earlier during my remarks, there's no rules of evidence in the Constitution. Nonetheless, the Senate will very likely vote on issues like what evidence will be admitted and whether or not hearsay will be considered. My guess is there will be an army of evidence professors and professors and trial lawyers who are going to help school the House managers, assuming impeachment does go forward, and I do believe it will go forward. And there will be a monumental effort to get that evidence in front of the American people. But I agree with you that when it comes to well, again, it's interesting, you know, in a criminal trial, you have your Sixth Amendment right to confront your accusers. In an impeachment trial, there is no Sixth Amendment right, believe it or not. So it's an interesting question as to whether, you know, for example, one of the arguments he's been making is that the whistleblower has not testified yet. I won't out that issue, Lisa. There has been a substantial question as to whether that's even relevant. What really matters ultimately is whether or not the evidence is sufficient to meet the burden of proof that each individual member of the Senate considers to be the applicable burden. Yes?
Sorry, but that's wrong. It's wrong. Look, first
What's
of all,
wrong?
it's not. There's an exception to the hearsay. It's when you make a statement that's against penal interest.
Right.
And the fact is that anything that other people hear that Donald Trump has said that goes against high crimes and misdemeanors would fall under the same exception as any hearsay exception because it goes against his interest. We're not calling penal interest because we're not talking about a criminal trial. But in this case, it would be impeachment interest.
Well, what he's talking about, I think what he was talking about was that people did not hear Trump say it, but someone has to be able to say, according to what
They were all part of the conversation.
were they all in the same room with Trump?
Well, hearing the conversation,
Right.
if they're hearing Trump,
Right.
that is an exception to the hearsay rule.
Right.
You are allowed to discuss anything that somebody has said that demonstrates the commission of a crime. No, wait, there's more. But that's you're talking about what's happening in the House.
Right.
In the Senate, there are people who have already come forward and have come to the House who have said, we have heard what President Trump said. That is an exception to the hearsay rule. Easy. Another thing, what's that?
Well, actually,
But it is against, and I'll tell you how. Well, no, but that's the next point. It's against his interest because it is illegal to deny the execution of a legal congressional what was it? It wasn't an act. They were providing money to Kiev, and it was being held up by the president.
Well, I would take it one step further, though. Hold up one second. I would take it one step further, that under the rules of evidence, any statement, doesn't even have to be against your penal interest, any statement made by any party is an admission. And I didn't understand your question to mean that. I thought you were talking about those third and fourth hand accounts, or the really second hand accounts. But anything that anyone heard the president say firsthand is not hearsay. Under the federal rules, it's not even an exception to hearsay. Under I think it's Rule 801, it's an automatic admission, and it doesn't even have to be, anything he says is admissible. The way I understood your question was, I thought you were talking about the second and third hand accounts, and that was what I said to you. I really believe that the statements that people overheard, like him talking on the telephone, both the transcribed conversation with the president of the Ukraine, as well as some of the statements he had with Ambassador Sondland, who also, by the way, can testify about those admissions, and it won't be hearsay. Those statements, I think, are coming in. I agree with Ian, Professor Heller, on that issue. But here's the. Oh, go ahead, Scott. Okay, let me keep going with this, because I do want to get to the critical question that I really was anxious to hear people talk about today, which, very simply put, today, based upon the evidence you've heard so far, how many people would say, I would convict Donald Trump for commission of high crimes and misdemeanors or bribery under the Constitution, by a showing of hands? Okay. And how many people against? Okay. Well, let's actually, no, I have to say that's a very interesting question. And so what I want to do is just go back for a second.
I'm not even a professor, and I know the answer to that.
So let's just go through it for just a second. So first of all, you mentioned mentioned Title 18, which I tried to emphasize at the outset. Bribery is not measured by what's in the federal statute. It's a question of whether he either asked for or received something in consideration. He doesn't have to get it. Ask for it or receive something of consideration as a result of some sort of either quid pro quo or a requested quid pro quo. It doesn't have to be an actual quid pro quo. So in this instance, the allegation against Donald Trump was that he ransomed congressionally approved military spending, which was supposed to be provided to Ukraine, and he ransomed that against the demand that the president of Ukraine announced on CNN an investigation of Burisma, which is the organization that was employing Hunter Biden, and also he wanted him to mention that he's investigating Joseph Biden as well. Now, I was thinking about the impeachment of Nixon. Let's see. Oh, I'm in the wrong. 1 second. I want to go to Nixon because I thought this was interesting. If I'll ever find it, hang with me here. Hello. I thought I was going the right way. How about now? Am I going the right way? Ah, is that a great? That's the best picture of Richard Nixon I have ever seen. Okay, tricky, right? So let's see. Did I pass the articles of impeachment? I'm still going the right way. Okay. So I'm going to. I wish I could take this mic with me, but I can't. So you know what I'm going to do? I'm going to do the Freddie Mercury thing and take the whole thing here. So let's just take a look at this for a second. I know.
Can we use this one?
That's okay. Freddie and I have so much in common. All right, so let's take a look at number 2. It says, Article 2 alleged that Nixon sought to have political enemies audited by the IRS. Audited by the IRS. And let's just stop for just a second about that. If Donald Trump, instead of asking the IRS to investigate his enemies, asks a foreign leader to investigate his enemies, to what extent do you think there's any real difference between those two concepts? To me, at least, and again, I said I wasn't going to editorialize until the end. To me, if anything, this is not nearly as bad as what Trump did, and I'll tell you why. Let's say for just a moment that the next president learns from this. Let's say that Trump is acquitted for the moment, and at least from a political perspective, that's likely. I'm not saying it's going to happen, but that's the current conventional wisdom. Let's say Trump is acquitted. Every president learns from the prior president. And if you follow the last 3 presidents, you'll know exactly what I'm talking about. Remember Bill Clinton testified at a civil deposition? I don't want to say he was caught with his pants down, but he clearly lied, right? Or at least there was certainly an allegation he lied. He testified at a civil deposition. He got caught in a problem. Donald Trump won the election, or so we think, in November of 2016. In November, at the end of November 2016, do you remember something that he did with respect to one of the lawsuits against him? He settled it. He settled the lawsuit that was brought against him for creating Trump University, which was regarded as a fraudulent university. Why did he settle that case? Because he did not want to testify. If he had to testify, he might have gotten caught in something, so he settled. That's the lesson he learned. What's the lesson that the next president is going to learn about what happens with foreign leaders? Let's say, for example, the next president, let's say, pick a presidential contender. Let's say Amy Klobuchar. I'm not saying Amy was, Amy, you're fine with me. I'm not saying it's you. Just the first name that came into my head. Let's say Amy, who's that? Okay, let's use Bernie Sanders. Let's say, for example, actually that may be a better example. Again, I'm not saying anything about you, Bernie, but let's say, for example, the Iranians want Bernie Sanders to be the next president. So they call up the Bernie Sanders campaign and they say, you know what? We've got some great oppo research on Elizabeth Warren or Donald Trump. Why wouldn't he take it? And better yet, why wouldn't Elizabeth Warren call up the president of Iran and say, you know what? Pick me. Suddenly, we have presidential contenders vying for foreign leaders' approval. Why? Because they know that there's an unlimited amount of money and a little unlimited amount of resources that can be deployed in an American election to select the president of their choice. So what happens is each ensuing president, instead of soliciting the approval of Americans, is going to be soliciting the approval of foreign leaders. That's the risk, to me at least. See, him using the IRS for political purposes, that's terrible. But people using foreign leaders' assistance, that is only going to induce presidential candidates to solicit the approval of foreign leaders. And before you know it, it won't be Americans choosing presidents. It's going to be other countries. Yes, Heath?
Well, I just think the lesson surrounding contempt of Congress is huge, too.
Absolutely.
Because the rule of law, I mean, he's blocking every subpoena that has been asked of him from Congress, and it's terrible.
And what lesson are we learning there? The next president will know that he never has to, or she never has to, let a single member of his or her staff testify in Congress because you can get away with it, which is what
the balance of powers, which is the essence of our Constitution. I mean, it's right to the heart of the rule of law.
And ultimately, when you think about the Constitution, think really about what makes our Constitution truly extraordinary. Because although there are significant problems with our Constitution, like, for example, treating persons of color as 3/5 of a person, I mean, it's not a truly enlightened document in every respect. But here's what's really amazing about our Constitution, and that's the concept of checks and balances.
Exactly.
What happened, and if you haven't read any of the materials on the Constitutional Convention of 1787, it really is a tremendous read. And I'm not just saying this because I'm a constitutional law professor. It's an amazing read. All of the deals that were struck that made it possible for the Constitution to be approved, they're truly extraordinary. From the House being popularly elected to the Senate being selected by the states, the Connecticut Compromise, I think that was called. There were one compromise after another. And the critical component of each of these compromises was no one branch of government can predominate.
Yep.
It's the ultimate rock, paper, scissors, if you will, of political governance. Each party kind of has a little bit of an edge on the other, but no one can take full control. No one wins every time.
Yes.
And and I think, Heath, your comment is right on point. If the President of the United States can instruct the members of his or her administration not to show up and respond to congressional inquiry, congressional oversight is a dinosaur, and it's gone. Great question. Yeah, could you just hand that to Scott?
So regarding Ukraine, there was a legitimate investigation happening already in the country to Burisma when we know Hunter Biden, Joe Biden's son, was on the board. We don't know why, and we know he got a lot of money. So there was, let's say, some smoke there, right?
Sure.
So let's say, for argument's sake, that Joe Biden was not running. You know, he's no longer vice president. He's a regular Joe. He's not running for president.
Right.
President Trump calls the newly elected president of Ukraine and says, "Hey, why aren't you guys investigating? You know what happened with Burisma?" And Joe Biden. I heard Joe Biden told your prosecutor to drop the investigation. Can you investigate that? Is there a problem?
Oh, there's a problem with your question, though, because that's not what happened. What happened was Joe Biden, along with the ambassador to Ukraine at the time, the representatives from the European Union, everybody was calling on not dropping the investigation, but to fire the prosecutor because that prosecutor was not doing a corruption investigation. And so what really, to me, bothers me the most about this, something we haven't talked about yet, but which is really important, is that after everyone supported the removal of this prosecutor, the president of Ukraine was seeking election, and his platform was a reform platform, and it was an anti-corruption platform. The congressional military authorization was actually linked to corruption. It really was. There was a specific line item in that legislation that said that you have to make sure that they're taking steps to eliminate corruption. So that would really support your point, except one thing, and that's that in May of 2019, 6 months ago, the Department of Defense specifically made a finding that the Ukraine was, in fact, resolving the issues of corruption and had satisfied that line item, which means that Donald Trump, when he refused to release the money, wasn't doing it because of the corruption piece, because the Department of Defense specifically found that the corruption was being investigated. He did it because and that's why Ambassador Sondland's testimony was so critical. And by the way, if you follow me on Twitter, you'll see I actually posted a tweet on this very issue. What's really remarkable about it is that Sondland said Trump really wasn't interested in the investigation. He just wanted the announcement of the investigation. And that, to me, says everything you need to know about what his motives are. So now I'm sort of editorializing. I told you I would.
Let me ask it differently then.
Sure.
And Trump or not, let's say there is a legitimate concern about a politician. Maybe he's not a politician anymore, but a politician involved in some type of corruption, whether it's in a foreign country.
Right.
And the president asks the leader of that foreign country to investigate. And let's say 2 months later, that subject politician, announces he's running for president. So now is he immune from investigation because now he's a political opponent of the current president?
No, but I don't think that's the same fact pattern.
It's not the same fact pattern, but I'm just, it's a hypothetical.
Yeah,
Obviously.
I mean, to me, if Donald Trump were really interested in rooting out corruption of members of political families who are benefiting from the offices of their parents, I think he'd have a really tough investigation of Ivanka Trump and Jared Kushner, because those two, I mean, she got a series of patents and trademark applications granted in China under very mysterious circumstances. They're making a ton of money at these hotels.
No doubt about it. But
that's troubling.
But no doubt about it. But the question is a presidential candidate immune from investigation, a legitimate investigation?
Absolutely not. But I don't. And if the fact pattern were that the Ukraine, for example, were in the midst of investigating Hunter Biden, and that Donald Trump either took no action or provided material assistance because it was requested, that would be one thing. But that's just not what happened. What happened was there was a prosecutor who wasn't doing his job. Basically, the world stepped in and said, you know what, this guy isn't doing his job. He needs to be fired. Otherwise, you're just a corrupt organization. The new president comes in. He's a reformer. The prosecutor is fired. The corruption investigation actually starts to ramp up. The Department of Defense says, we like what you're doing. You've satisfied the requirements for the funding. You get it. And then Donald Trump, holds back the investigation. And when he gives it up? Does anyone know when Donald Trump finally released the funding? Because he did. After the whistleblower complaint was released, when he got caught. And so to me, and listen, Scott, I believe me, Scott is a terrific lawyer, and he's trying to create a good counterbalance, which I really respect, Scott. I think that the case against Donald Trump is the most powerful impeachment case in the history of our republic, because I agree with most of the people in this room that Bill Clinton's impeachment was purely political. It did not pertain to an issue of public trust. The Andrew Johnson impeachment, as you pointed out, and during your very nice summary of that conflict, that was really a political dispute that sort of metastasized into an impeachment inquiry. This, to me, is not a political dispute. This is, in my view, a public wrong that was done. The misuse of the office, the effort to use the levers of government, not for the advancement of a policy agenda that would benefit all of us, but for a political agenda that benefited the candidate, in this case Donald Trump specifically. To me, the argument in favor of impeachment is overwhelming, which is why when people ask me, do you think it's possible that the Senate will convict? I actually think it is possible that the Senate will convict. I know that there are those who feel it's unlikely, and I agree it is unlikely, but I do think it's possible. Remember that Richard Nixon's impeachment was by no means a far-gone conclusion until, as Scott pointed out, 5 days before, when the tape recordings were released, and Howard Baker Jr. led a group of Republicans and said, "We can't carry your lunch for you anymore. You got to go," and he resigned. That moment could still happen.
No, listen, I'm not defending Trump, but what concerns me and what has concerned me a little bit is the notion that some people seem to be suggesting that simply because the subject of the proposed investigation was a political rival, that is, impeachable offense, which to me would mean that, you would be immune if you just because you're running for president against, the current president, that you'd be immune from any type of legitimate investigation.
Yeah, I get that. I definitely get that. There were some questions. Sure.
We know that the founders were concerned, as you said, about it being a political process, which our history has shown. Is there any way, that's why they made the 2/3 requirement in Senate, and it's still checks and balances from the House to impeach and then
Right.
the conviction. I get all that, and I see why it's there, but it feels like we can't, it really has no legitimacy because it is such a political process where these overwhelming facts, and we know it with almost certainty that he won't be convicted on them. It's a terrible thing. Like, I don't know who else could be charged with that other than the Senate, but I'm wondering if you had any thoughts on that.
Yeah, it's interesting. The commentary by Alexander Hamilton was that you have to really be leery of factionalism and partisanship, and that's why the vaunted assembly of the members of the Senate would be a check and balance against the sort of rabid political mob that might take place in the House. And so I understand that perspective. It's interesting also that the leader of the House manager group during the Clinton administration, during the Clinton impeachment, was a guy named Lindsey Graham, who is now Donald Trump's chief defender. Let me say that again. The lead House manager for the Clinton impeachment was Lindsey Graham, who is now Donald Trump's principal defender, and who has said publicly that he's not even going to read the transcript because he doesn't even need to because it's so clear. I think the best way for us to really solve this problem, and I think it's a huge problem, is to recognize that the Senate's what's going on in the Senate is not something that exists in a vacuum. It's a reflection, I think, of society today, and I think that starts actually, unfortunately, with the politicization of the media. When people ask me about this, I'm often prone to saying that if Fox were around during the Nixon impeachment, Nixon would still be president, and he died over 20 years ago. There's no question that the politicization of society as a result of the politicization of the media really has created an environment where there are alternate versions of the truth, of reality. And so, for example, the conversation, the dialogue we're having right now, and even with Scott, who disagrees with me, which, like I said, I respect that, we can have this dialogue back and forth, and it can be an intelligent dialogue. But having traveled across the country in an RV, where I literally grassroots, I saw everybody, okay? The perspectives of people are really shaped by the media that they are engaged with. And it's not just Fox. There's, Breitbart. There are all sorts of Sinclair News, which is a local and regional news organization that is very heavily right-leaning, and it owns 73% of the media markets in the United States on local news. At one point, the local news anchors were all received a directive from headquarters at Sinclair directing them to read statements that were favorable for Trump and hostile to Democrats. It's a very serious problem, and I think the real place where we need to start this is to try to find a way for the FEC to regulate the media in a way that doesn't offend the notions of the First Amendment, while at the same time does focus on creating a realistic news setting. I remember when I went down to Florida to speak to undecided voters on behalf of the Clinton campaign, the Hillary Clinton campaign, and I was amazed at what they came up with. They had like sheets of paper about all the issues. And someone once came up to me and said, look at this. It shows that the Obama administration signed more executive signing statements refusing to comply with congressional directives than all the other presidents combined. I said, where did you get that from? She said, look, it's whitehouse.gov. I looked at it, and sure enough, someone had typed in whitehouse.gov on it. But what she didn't see was that had been placed on that page by the website that she actually went to. It was not whitehouse.gov. You know what it was called? vulcansarecool.com. vulcansarecool.com. And so people, when they see these things, it's hard for them to know what's true and what's not. These things didn't exist during the Nixon impeachment. So there's a really, like I said, there's a larger societal issue. And what I would say, just in closing on this point, is I think the best elixir to what we're dealing with today is better engagement, better civics, teaching civics in school. There are books coming out on this very issue, as a matter of fact. I think it's really important that we make sure to emphasize civics in school and really focus on that, because a better educated society is an armed society, armed with information, not guns. Armed with information, the more information we have, the better and more reliable information we have, the more likely we are to avoid those pitfalls, and we can start electing leaders so that we can go back to a people's house and a Senate that is really a sober and dispassionate Senate. And another way to do it, by the way, is to get corporate money out of politics. That's a whole other conversation. But we get corporate money out of politics, we have a more educated and engaged society, and then we'll be able to make real changes. Thank you very much, guys. It was great. And thank you, of course, to Scott, Waller, and Fatima Afi with their great presentations. You guys were amazing.